Hello friends, in this video we are going to study Article 19 and Article 20 of Indian Constitution, which is about the fundamental rights. And what we are going to do in this video, I have given the exact wording of the Constitution about those articles, and we try to explain those articles with some examples. The Article 19 of the Indian Constitution says that it's about right to freedom. So what it says that freedoms in different forms, and these are freedom of speech. Many times you will heard about that it's a violation, because recently I come across an example where a reporter is saying that my freedom of speech is taken away by the military forces or by the forces. So they are charging that I am not able to exercise my freedom. We'll talk about this in the later phase also. We'll talk about it's about the freedom to assemble peaceably without arms, to form association or the unions, to move freely throughout the territory of India, to reside and settle in any part of the India with some exception, to practice any profession or occupation, trade or the business. Now, now there the clause start. Nothing in the subclause A is this one, of 1 shall affect the operation of any existing law, or to prevent the state from making any law insofar as such law imposes reasonable restriction on the exercise of rights conferred by the said subclause in the interest of sovereignty and integrity of the India. For example, I have given you that reporter and the forces example. If a disturbed area is there, if we provide, if the forces are not there, then there are chances that disturbed area may further become more disturbed, and it will take away the right to life, means it will take the life of people. So in that case, to save the major problem, there are chances that it may hurt the rights of some of the people. For example, that reporter have the right to say, because that is their work, to put forward the views of the people in front of the government or in the public. But there are chances that there are threat to that reporter's life also, because that is a disturbed area. So in that case, the forces, what usually forces do, they go for a give priority in terms of their life is more important. Then further things will come related to development aspects and other. So, and another is because there is a need to maintain sovereignty and integrity of the in India, and security of the state, as I mentioned, and friendly relation with the foreign states and the public order, decency, morality, or in relation to the contempt of court, defamation, or incitement to an offense. For example, the court has given any order, and we can challenge that order, but through proper means, in terms of in a court. Not we can't go for that satyagrah kind of thing, not satyagrah, I would say dharna kind of thing, we on the road on the court order. Definitely court will hear us, but there is a proper channel and proper means. If you go by the other means of by putting everything on halt and by stopping all the roads and all the railway channels, then it will propagate the anarchy in the system, and there are chances that further ill elements in the society will emerge to take advantage of the situation, and the whole system will get ruined. So in this case, there is a need to follow proper channel. Now, nothing in subclause B, it is assemble peacefully, shall affect the operation of any existing law insofar as impose or prevent the state from making any law in the interest of, again, when it's about the sovereignty and integrity of India, there are chances that they can stop, because you see in many times we see that there are conflict in a particular region, then in that case they put a rule that okay, nobody will come out of the house, because it will help the forces to control the ill elements in the society, as well as it will protect the life of the people, because it helped to maintain public order, reasonable restriction imposed on the, and move freely. This article says we can move freely throughout the India, but to there is a need to take permission when we are going to restricted area in terms of tribal areas. So they need to take permissions. And this one is about now what else we can include in right to freedom. There are many things. So like nothing in subclause C of the said clause shall affect the operation of any existing law insofar as imposed or to prevent the state from making. So whatever A, B, C, D, E is there in our fundamental rights of Article 19, they will not affect the any law which is imposed to prevent the interest of what sovereignty and integrity of India, public order, morality. So there is a certain restriction to safeguard the major goals, which is the sovereignty and integrity of the nation. Now that nothing in one subclause D and E of the set shall affect the operation of any existing law. Again, this one is about the restriction on any exercise of the law conferred by the said subclause, either in interest of the general public or for the protection of the interest of any scheduled tribe. Okay, there are chances for the general public also and for the to safeguard the interest of scheduled tribe. G. Clause shall affect the operation of the now imposed reasonable public. So now they are saying that okay, you can take any occupation, but there is a need to have a professional and the technical qualification necessary for exercising any profession or carrying out. It's not that okay, fundamental rights have given us the occupation to exercise any occupation. It doesn't say that. Occupation requires certain skills. That skills, if you have, then you can start that thing anywhere in throughout the country. And that occupation need to be followed by the certain standards like trade, business, services. They need to follow certain kind of standards. So now the Article 20. Article 20 is very interesting article. Why? Because it gives protection against the arbitrary and excessive punishment to an accused person. So it says that no person shall be convicted of any offence except for violation of law in force at the time of commission of the act charged as an offence, nor be subject to a penalty greater than that which might have been inflicted under the law in the force. So a person is there, if any he did any offence, then he will punished according to the law, and according to the law only he will get the sentences. No person shall be prosecuted or punished for the same offence more than once. Suppose he did one crime now and he is punished for that crime, and after sometimes he can't be punished for the same crime. So this is the second safeguard given to the person. No person accused of any offence shall be compelled to be witnessed against himself. Okay, if he did something, just he can't be forced to say that okay, you have done this thing, so just go for give oral evidence or any documentary evidence. So it is against the self incrimination, and it's both in form of oral and in form of document. uh, आपसे ही नहीं बोल देगा कि भाई चलो बताओ आप कि आपने ये जुर्म किया है कि नहीं किया है बॉस. ठीक है. So these are the two articles which we studied, and in the next article we'll study Right to life, which is very, very, very important article. Thank you so much.